Okay, we're on the record. Go right ahead.
Today is Wednesday, July 18, 2007. We're at the Sheraton Waikiki Hotel in Honolulu, Hawaii. We're here today to interview Judge Robert Broomfield in a brief video oral history to supplement a longer, more complete audio oral history. I'm Paul G. Rosenblatt, and I'm here on behalf of the 9th Judicial Circuit Historical Society. Mahalo, Bob.
Mahalo.
This is a wonderful place to be having a conference, isn't it?
It is. No
Bob,
coats and ties, PG.
We've taken your oral history before in quite some detail. And as I mentioned, this is a more of a supplement to that oral history. But could you tell us how you came about your decision to become a lawyer?
It happened when I was in the 6th grade in a little town outside Pittsburgh called Sewickley. The teacher had said to us, divide us into groups of 2, and we went over to the library to make a presentation to the class. And I came back, and the 2 of us made our presentation. And at the end of it, the teacher said, little Bobby Broomfield should be a lawyer. That never left me. There were no lawyers in the family as far as I know, although some family members think that we might be related to Justice Van Deventer, but he spelled the name differently, so that's probably not true. But that stayed with me. And I remember when I was in the service, I had narrowed it down to 5 choices what I'd do with my life. And I ultimately picked the last, decided to go to law school, was going to go to the University of Pennsylvania, knew I was going to stay in Arizona, so I decided to go to the University of Arizona Law School.
So this was basically your own sole decision based on the
That's
teacher's recommendation to
That
you.
comment never left me.
Did you have other influences or role models that were involved in that process?
No, my father was in business, had no other interest. I had gotten married. My brother-in-law was an Air Force pilot, wanted me to stay in the Air Force. I was in at the time. But I guess that little message that was sent to me in the 6th grade stuck.
So after you made that decision to go to law school, what made you go to the law school that you attended?
Well, that's what I just indicated. I was going to go to Penn because I was from Pennsylvania mostly. I'd been born in Detroit and lived in Chicago for a while, but it was mostly the Pittsburgh area. And I had gone to Penn State undergraduate school. So I had come out to Arizona and met the person who was to become my wife. She was a native Arizonan, went overseas for a year, came back, and that's when I decided to go to law school. And it was going to be Penn until I decided, well, I want to stay in Arizona. I really liked it. And I said, why am I going to be going to law school in Pennsylvania when I'm going to stay in Arizona? So I applied to Arizona, and fortunately they took me.
When did you graduate?
1961.
And what did you do immediately following law school?
Of course, as you know, the University of Arizona is in Tucson, and I knew nobody in Tucson, but the city had grown on me. If somebody had offered me a job, nobody did, I would have stayed in Tucson. But we'd always anticipated coming to Phoenix, and so we came up, and I became a law clerk to Jack Hayes.
And how long were you with the judge?
6 months. And then I went with a law firm, then called Cunningham, Carson, and Messenger, and now called Carson, Messenger, Elliott, Laughlin, and Reagan. Was there for 9 years.
And what type of practice did you have with that law firm?
Pretty much a general practice. I'm old enough where you could do such a thing, but I did a lot of concentration in real estate.
Do you have any memorable cases that come to mind?
Not really, ironically, I suppose the most memorable is a bankruptcy case, because I did very little of that, but I had a bankruptcy case. It was a very complex one before Judge Walsh in Tucson, as it turned out.
Was that your first experience in federal court then?
No, I'd been around for a while. I remember my very first experience in federal court was in Phoenix, and I'd gone in to be admitted. And when you were before the judge, there was only one at the time, he made you stay. And he went through a criminal calendar, and he would assign counsel at the time. He assigned me to two people. We went in the back of the courtroom. The fellow was very knowledgeable. The defendant was very knowledgeable, told me what he wanted, and said, "You get me that, Sonny," and everything's okay. So I went over to talk to the U.S. attorney, and we made a deal, went back before the judge, and he entered his plea right then and there. This was all before Boykin versus Alabama. It was pretty simple. Everybody was happy, including the defendant.
And was he sentenced right then?
He was sentenced right then and there, yeah. That was all over.
It was a simple world
time,
then, wasn't
yes.
it? Tell us again how long you practiced with Carson Messenger?
9 years.
I see. And how did you become a judge?
I was sitting in my office one day, doing my thing, and one of my senior partners, a man of few words, he opened the door and he said, "You want to be a judge?" And I said, "What?" And apparently, at the time, the then governor looked to a committee of lawyers when there was a vacancy, and one of the Superior Court judges was resigning in midterm for health reasons, and this committee had somehow become aware of me, and they called my senior partner and said, "Go find out if he wants the job." I initially said no, but my wife and I, Tuma, talked about it later on, and eventually changed my mind. I was appointed, and that started the judicial career over 36 years ago.
On the Superior Court of the state of Arizona.
Right.
Do you have any memorable cases of your years in that position?
Oh, I have a few. One time it was in a juvenile case. The juvenile was very nervous. There were drugs involved. Drugs were placed before him, and there was some conversation about it. And then we went off on something else, and the other people asked him questions. And then it became apparent that the drugs were no longer there. It turns out that the young fellow had become so nervous, he picked one of the pills up and ate it in front of all of us, and none of us saw it. I say it was a juvenile case. It wasn't, because it was a jury trial. I can't remember now what the issue was, but I had to dismiss the case and tell the jury that the case was over because the defendant ate his own evidence.
How many judges were on the Superior Court in Maricopa County at that time?
When I started, there were 22. When I left, 14 years later, there were 50, plus another 25 commissioners.
Do any other cases come to mind that you presided over?
Well, there was another one. This was a juvenile case. The juvenile testified, and the witness chair was to my right, and the door to get out of the courtroom was to my left in the back. He testified and walked down, and he had been hyperventilating. And when you hyperventilate, nature's way is to stop you from breathing, and when you stop breathing, you pass out. As he was walking right in front of me, he just went right on down. He recovered quickly enough, and everything was fine.
So you sat both as a juvenile judge and a adult judge or a regular Superior Court judge?
Well, in Maricopa County, because the court was so large, it was an assignment to the juvenile division of the court. So I was there for about 2.5 years, maybe a little more than that, at a separate location. But I had also, previous to that, had a calendar that tried usual civil and criminal matters. It was also specialized probate in Maricopa County at the time.
And then what happened?
Things happened to me in strange ways, I guess. I was up in the White Mountains in eastern Arizona on vacation fishing with my family. I had to come down to Phoenix. It was about a 4-hour drive because of a budget hearing with the Board of Supervisors. This was dealing with the juvenile court, making the presentation to get our budget. I made the mistake of going home after I'd had this budget hearing to get something because my wife had asked me to stop by. The telephone rang, and it was a representative of the then Chief Justice, Justice Hayes, who said, "The Chief Justice wants to talk to you." Well, with him, you called him right back. I called him right back, and he said, "I want to appoint you the presiding judge of the court." Kind of like my law partner. Man, a few words. And when do you need to know? Well, let me know right now if you can. I said, "Can I talk with my wife about it? I'm up in the White Mountains." He said, "Call me tomorrow morning." So I went back. He called me I went into town the next morning, called him up and said I'd do it. So for the next 11 years, I was the presiding judge, or chief judge by federal terminology, of the court.
And the job description becomes dramatically different, doesn't it?
Oh, does it ever?
Tell us about that.
Well, in that court, it's at the time it was about the 8th or 9th largest trial court in the country, and so you spend an awful lot of your time on administrative and other type matters. I appeared in the legislature a lot, did a lot of things like that. But you dealt with the operation of the court. And ironically, it was really an interesting time for me. We were able to do some things with the help of all the other judges in the organization of the court. We did a lot more specialization than we had had up to that point in time. And probably the thing that was the most interesting was reducing trial court delay. In the mid-'70s, the National Center for State Courts had become interested in that. And they were surveying courts to see if they could get a project going. They wanted to get 8 courts across the land who would start a project, the objective of which was to reduce delay in processing of cases, civil and criminal, in the courts, large municipal, metropolitan courts. Well, we decided that we would do it along with 7 other large courts in the nation. Some of those courts really had horrendous backlogs. In the Bronx, which was one of the courts, they were up to 7.5 years. In Phoenix, it wasn't nearly like that. It was maybe 2.5 to 3 years, much more than it should have been. So I asked 5 of my colleagues if they would participate in this project, and all 5 agreed. One of them, however, the next day called me up and backed out. I won't tell you who it was. You know him very well. I think he thought I was nuts to try to do something like this. But the other 4 decided that they would stay with it. And a very interesting thing happened. After we'd gone through all the planning, which took several months, we were going to announce it to the public, to the lawyers, and we did through the media and the bar publications, and then we had a hearing. Each of the judges had so many lawyers from a number of cases it took from their calendar. And this process was going to be explained to them in the courtroom. And the idea was for me to go on the bench, and the other 4 judges, robes and all, were going to sit in front of the bench facing the lawyers in the spectator area. Well, we're in the chambers of one of the judges. It was Mel McDonald's chambers. And his bailiff came in and said, "We have a problem. There's so many lawyers out there. They have occupied the entire spectator section, and they're standing in the well of the court, and it takes up the entire well. And that's only half of them. The other half are out in the public hallway." And we looked at each other, and I thought, oh, what a terrible thing to happen. The whole thing's going to go down in flames. And bless her heart, one of the judges uttered 4 words: "Let's go do it."
Who was that?
Her name was Sandra Day O'Connor. And so Sandra and the other 3 judges, Jerry Strick, Charlie Hardy, who was one of our colleagues now on the federal court, and Mel McDonald, they went out and they sat in these 4 chairs looking up at the lawyers like that, who were right next to them. And I was on the bench, and I explained the whole program, and we let the lawyers go, and then we brought in the second half and did the same thing. Had she not said that, and had we not gone out on the bench, that program would never have gotten off the ground. And the ultimate irony of it was the most successful of the 8 courts in the land, and for a time was a model, not because of anything I had done, because I did very little, but because of what the other judges did and what the lawyers did. There was tremendous lawyer cooperation. It's what really changed the system of how we deal with cases. We moved from lawyer control of calendars, which is how it was back then, to judge control of calendars. It was a sea change, and Sandra had uttered those 4 words.
As presiding judge, did you get to go in the courtroom much?
Not as much as I had wanted, but I did manage to get in. I had to keep my hand in it.
I see. Tell us about your transition then to the federal court. How did that come about?
Well, it's somewhat the same thing. There was a vacancy in the court, and the federal court, and one of the judges, the one who was creating the vacancy by going senior, called me up and said, "I'm going to go senior. If you want my seat, you better do something about it." I contacted a few people, and the rest is history. I was eventually...
Who was that?
Carl Mickey.
Tell us about your confirmation process, Robert. How did that
Mine was odd. As you know, I was born back east, and that's significant. I had received word from the FBI they wanted to interview me, so the agent came out and interviewed me, and he was very nice, and he said, "Well, it's going to take a while." So a few months later, I get this call on a Saturday morning from this FBI agent, and he told me, "Well, the report's over. We've sent it in. Everything's just fine." And they said, "Oh, by the way, did you know you had a restrictive covenant on your house?" Well, I almost fell over. I picked myself up, and I said, "What are you talking about?" And he said, "Yeah." And I get out my title insurance paper, and I never looked at the thing when I got it. And sure enough, this place was, a restrictive covenant was put on this whole subdivision area in 1946. Well, I didn't think much more about it because under Shelley versus Kramer, it wasn't enforceable. There was nothing you could do with it anyway. And so that was just the end of it. Well, I go back to when I'm supposed to go to my confirmation hearing, and I'm waiting outside a few minutes before 2, and here comes one of my law school classmates, Gene Karp, then the administrative assistant for Dennis DeConcini, a senator. And he said, "Bob, we have a problem." I said, "What do you mean?" He says, "You've got a restrictive covenant on your house, and they're looking for a way not to have the hearing." I said, "I was 13 years old and lived in Pennsylvania when that covenant was put on. It's not enforceable. You know that." He said, "They're looking for a way to not have the hearing." And about that time, Dennis DeConcini came up. And Gene said, "Bob, tell Dennis about what it was." And I repeated that whole story. And Dennis started laughing. I didn't think it was very funny at all. But he stays there. And so we go in, and there's a hearing with the chairman, then at the time Senator Thurman, and Senator DeConcini, who was pretty senior on the committee, and the most junior member, Senator Simon from Illinois, whose job it was, I guess, to get the hearing set over because of the situation. And Dennis talked first, and he said, "Bob, I understand," and he went through the whole thing. He said, "Tell us about that." So if you look at the congressional record, you'll see the story that I just told you, told to those three senators.
And then
I was confirmed. The reason for not having the hearing disappeared.
Bob, did you have any judicial mentors or role models that you can recall and tell us about?
Jack Hayes was more than anything. He was a Superior Court judge. He had been the U.S. Attorney and then a Superior Court judge, and then went to the Supreme Court. Was the first member of the Supreme Court to break the rule of rotating the Chief Justiceship once a year. He stayed there for 3 years before the constitutional amendment that made it 5 years. He was my mentor.
Do you remember your first day on the federal bench?
Oh, I'll never forget it. It was a Monday, and I was to be sworn in at 4 in the afternoon. But I decided if I was going to be paid that day, I would show up early. So I show up at 9 in the morning. And at the time, our chief judge at the time was Richard Bilby. And he came about 9:30. And it turned out that he had had a hearing the preceding Friday over some case that eventually involved a lot of lawyers, actually 85 lawyers, every bank in Arizona and Utah, a whole bunch of things. The prayer eventually was ginned up to $1 billion. This is in 1985. That's real money. And so he comes and says hello to me, and he says, "I'm going up to talk with the lawyers. They're going to report to me on this case that I heard last Friday. You want to come?" I said, "Well, gee, I haven't even been sworn in. I don't have a robe here. I don't know." He says, "Oh, that's not a problem. We won't wear robes. You come on out." So I go out on the bench with him, and I sit there, and he doesn't introduce me to anybody. I'm just sort of sitting there. And we go through the whole morning, take a brief lunch break. We come back in the afternoon. This hearing is going on. About 3 o'clock, I begin to worry. Does he forget that I'm to be sworn in an hour? 3:15 comes, 3:30 comes, and I'm really beginning to panic now. What do I do? Tell this brand new judge-to-be is going to tell the chief judge, "Hey, stop your hearing so I can be sworn in." But at 3:45, he knew all along. He then says to all the lawyers, "Well, that's enough for today," and he made an announcement. And the most surprised person in the courtroom next to all those lawyers was me. He assigned that case to me on the spot. It lasted 5 years. I transferred it to the District of Utah and went with the case, went up there for major hearings. It was a very complicated case, my first one.
Do you have any memorable colleagues that come to mind?
Well, all of my colleagues are memorable. Of course, you and I both know Justice O'Connor, and she was our collective college on the state Superior Court. I don't know that I want to pick out any single one. I have a real affinity, however, I have to admit, for our brother and colleague, Bill Browning. He's a man of great integrity and going through some rough times now.
Tell us about some of your memorable cases as a district court judge. Well, ironically, two of the most memorable cases were in our Prescott Division, your old hometown. One involved the tribal chairman of the largest Indian tribe in the nation and in Arizona. And he and 31 other people were charged with a variety of crimes, conspiracy to commit robbery and burglary and kidnapping and other things. And I had a 4-month trial. We tried 11 of the 32. Half of them had entered pleas. The other 10 after the trial entered pleas. But the 11 most culpable were tried. One of those people became non-competent during the course of the 4-month trial.
So we finished the trial with 10 people. Ironically, he had been removed from his office by the tribal council, but took it back by force and was removed again, and then was conspiring to do the same thing yet again, take it over. And the police were there, and there was someone taking a video. And so we called it the riot case. For 2 hours, we watched a riot occur in the headquarters of this tribe. 2 of his supporters were killed, and all 10 were found guilty by the jury. He received the most severe term because he was the most culpable. The ultimate irony was he was pardoned, and some of his colleagues served longer terms than he did. Very interesting case. Another one was in Prescott also, involved Earth First with the exclamation mark, the folks who put spikes in trees to prevent loggers from cutting them down with chainsaws, because if they know that the spikes are there, they won't do it. And we had a trial with 5 people that lasted about 2 months, and then ended up with all of the defendants entering a plea in the middle of the trial, one of whom was represented by a lawyer who can remain nameless, but is known nationally, even internationally, who's never lost a trial. He had a co-counsel that showed up when his client entered a guilty plea.
So he still has never lost.
He still has never lost. I suppose it's his theory.
Bob, you've developed a reputation as a well-deserved reputation as an administrator. You became chief judge. When was that?
94.
All right, and you served that term, and now you're in another position, and I know you can't talk about a great deal, but you can, I believe, describe what the position is and the responsibility is.
Well, I suspect you're asking about the FISA court, Foreign Intelligence Surveillance Act court. I am on it. You're right, I can't say much about it. I can tell you what's in the statute. It was created in 1978. Actually, it started functioning in 1979. Didn't have a whole lot of business. Everything was changed in 9/11. There were originally statutorily 7 judges. The USA Patriot Act changed that to 11 judges. They added 4. I was one of the 4 that was added. And one judge got a 4-year term, one a 5, one a 6, and I got a 7-year term. It is a 7-year term normally, and that's how they staggered it in. And I'm in my 6th year serving on that court.
And so this, since you've taken senior status, demands a good deal of your time. Is that fair to say?
Well, I serve also on the Judiciary's Budget Committee. Between the two, I go back to Washington once a month.
Can you think of anything else that I haven't asked you that you'd like to tell us about?
I'm not sure that there's anything important about what I do or have done that we haven't covered.
Well,
I guess I can say I have been blessed to be on 2 outstanding courts, peopled by great judges and court staff, and it's made a joyous career for me.
Well, thank you very much, Bob. That concludes our video interview, one of the very first that we've taken of some of the really highly respected and highly regarded judges of the Ninth Circuit. Thank you.
Well, maybe you'll eventually get to those others who fit that definition.
That do it? Did we?
No, I'm only kidding you. Come on, Jimmy. I know.
That's the way.